v. Goliath.
Good morning, Your Honors. May it please the Court. I'm Andre Mouledoux, and I represent the appellants, the towing companies, in the long line of litigation out of Gulfport. Thank you for allowing us to present our case today on behalf of Central Boat Rentals, Global Towing Service, Offshore Towing, McAllister Towing, and Curtin Maritime. To begin with, I'd like to briefly address the key background facts on this case. This arises out of Epic companies having filed bankruptcy. Epic was in the business of decommissioning, that is, disassembling and removing offshore platforms whose production had ended. The wells were sealed, and under federal law, the platforms have to be removed from the Gulf of Mexico. Epic hired and was the charterer of the Goliath, which is a big derrick ship that goes and disassembles all the various components of these platforms. Epic also hired my clients, the towing companies, to bring barges to the Goliath to receive the various components of the platforms that were being removed. And I urge the court to consider what is an offshore platform. It's not just one item. An offshore platform, and I'm sure you've seen pictures of it, is a series of legs that go from above the water down to the floor of the Gulf of Mexico. That's called the jacket. On top of the jacket is a platform, a big work surface that supports whatever the operations are. A platform may have drilling operations, so it's got drilling equipment, or it may be a production platform, so it's got machinery and tanks and pumps. But when those operations are finished, it's time to remove the platforms, and that's what the Goliath does. It goes and it takes piece by piece these platforms apart. To perform its mission, the Goliath had to remove each component one at a time and place them individually on barges to receive those components. And I will tell you, the decks and jackets are typically bigger than the barges that receive them, and the barges are specially equipped with bracing and rigging in order to carry the key components. All of these projects are designed with details of sizes and how they're going to be placed on the barges. We're here today for the towing companies because we assert that the services that the towing companies presented to this operation were critical. They were absolutely necessary for the Goliath to perform its operations. The claims are based on the Federal Commercial Instruments and Maritime Liens Act, or the Lien Act.
The problem I have with that expensive reading of the statute is that you're going to open up this a whole, you expand the reach of the lien, and then it becomes circular all the way down. And
yes.
If you don't have some restriction, if you will, then the lien is really ultimately going to be nullified.
Thank you for that question, Your Honor, because I think that is an important question in this case.
Let me supplement it one other additional way. There's a case called Martin Energy versus Bourbon Petrol. Judge Duncan of our court wrote this opinion. I don't know if you're familiar with that.
Yes, Your Honor. The Martin Energy case is probably the most recent pronouncement from this case that is, I think, particularly relevant. And I really think it is on point and supports my client's position, and I will explain why. Martin Energy was a claim by Martin Energy, whose oil was sold and carried on the boats, a supply boat company. The fuel or the oil that was on those supply boats were not consumed by those boats.
They carried the extra gas for other purposes.
Yeah, it was to go to the surveyor boats.
But that points the necessity directly at the vessel. So how do you relate that here?
The court found in that particular case, Judge Higginbotham, that it was not a necessity for that supply boat to be carrying that fuel. Instead, the necessity belonged to the boats that were going to consume it.
It was necessary to its business success, but it was not necessary to the operational function of the vessel.
No.
He wasn't burning the gas, he was carrying it for that purpose.
Right. In this particular case, the Goliath is the surveyor boat that the fuel was going to be delivered to. There was a lien, the court observed, likely against the receiving party that got the benefit of that delivery. In this particular case, we are delivering the product to the receiving party. The barges here are similar to the fuel that was delivered. So the receiving party, and the court says, Martin Energy would likely have a lien against the receiving party, but you don't have a lien against the party that carried it. I'm going to tell you the liens against the barges that the towing company have asserted is in dispute, partially on that basis. But the key elements in the Martin case are, who was the lien against? It was against the vessel that received the benefit of that delivery. And in this particular case, Your Honors, is we provided necessaries to the receiving vessel because the Goliath could not perform its function, could not meet its mission unless it had the support of the barges and the towboats that not only towed barges there, they maneuvered them in the field. They brought them in for loading, took them away, brought them back to receive other loads. This is not a single lift case. The Goliath is repeatedly picking up the components off the deck, putting them on the barge. Then it goes and picks up the platform. Goes and picks up the deck, puts those on the barge. The barges are taken away, work is done, they come back to receive the jacket. So, with all due respect, Judge Higginbotham, I sincerely assert that that Martin Energy case supports our position. And I want to add also that Martin Energy case had some key wording that I believe supports our case, because the thrust of our argument before this court is what are necessaries. And the Fifth Circuit tells us that to decide whether a particular service or good is necessary is you look to the function and the mission of the vessel for whom the services are being rendered. Now, the Fifth Circuit tells us in Equilease, and if I can just do some quick quotes, in the Equilease case, which said an insurance policy is necessary, it said modern admiralty jurisprudence interprets necessaries broadly as anything that facilitates or enables a vessel to perform its mission or occupation. In the Gulf Marine case, cited by both parties, the court stated, necessaries are things that a prudent owner would provide to enable a ship to perform well its functions for which she has been engaged. The Trico Marine case, which we cite, and I'm going to discuss that a little bit more detail if time permits, tells us necessaries include most goods or services that...
Judge Duncan's opinion that picks up Equilease itself, but there's another line that follows that in his opinion. I'll just pull it up here. They said these are items useful to vessel operation and necessary to keep the ship going.
Right. And, Your Honor, I will submit that the Fifth Circuit uses...
Not just to do the business that they want to engage in. That's a difficult line that I've...
Yeah. But, Your Honor, I don't mean to submit that services that keep the ship navigating is a necessary, but supporting the function and the mission is also a necessary, and that's what we have here. And we cite in our brief these cases that allow liens to attach to a company that provides linens to a floating hotel, liquor to a cruise ship. These are not essential to the navigation, but they were essential to the function and the mission of those vessels. The Martin case, Your Honor, if I can bear with me, said this: the term necessaries has a broad meaning and includes most goods or services that are useful to the vessel, keep her out of danger, and enable her to perform her particular function. So it's not a narrow, does it support navigation? It supports the overall mission of the vessel. Your Honor, there's no question that Epic, as the charterer of the Goliath, had the authority to hire the services of the towboats in support of its overall purpose of disassembling the rigs, which was the mission of the Goliath.
Tugboats are vital to the, to say the least, to the ship's mission and to delivering whatever. They're vital to the in so many ways. But that's the difficulty of it. If it's just vital to the overall, to a particular business enterprise in which the vessel is operating, what is the limit then?
Okay. Your Honor, and you mentioned, gee, is it circular, et cetera. I would submit it's not unlimited. You have to meet the test of what is necessary. And I read these quotes of the Fifth Circuit. There is a decision of the Fifth Circuit that says when you look at the Lien Act, don't look at it as strictly juris, or they said don't even look at it as strictly jurissimus. My Latin may be poor, but that's in the late Charles Stevedore case. It says you have to look with a broader eye to support maritime navigation and the support of those who provide services. This is what the towing companies did here. It's not broad. You have to show that the service that you rendered, and Your Honors, I submit services rendered directly to the vessel, which is what the towing companies did. We provided the service of maneuvering its barges as needed and as directed by the Goliath. We're not some remote person in the chain. We did something here on land, and eventually it benefited it. We're in the field working at the direction of this vessel to deliver the services it needs. We don't get the directions from the barge lines. We don't get the directions from somebody's shore base. We get the directions out in the field as to when these barges need to be delivered, when they need to be moved, when do they need to be moved away, or the weather issues. We're there. And as I mentioned, the actions of the Goliath isn't simply picking up one item and its job's complete. Its job is to pick up, load, coordinate, bring the load back in. So in order to do that, you needed the barges for sure, and you needed the towboats to act on the instructions of the Goliath as to what to do. We submit respectfully that this Goliath cannot perform its work unless it has the barges and it has the towboats, which are essentially all the barges' motive power. It's an absolute critical, essential necessity. I want to talk about the Trico Marine Operators case, which is the Fifth Circuit case, which I think is instructional here. Trico was a case with a supply boat that delivered water supplies drill pipe to an offshore platform. It was hired by the charterer of the drill rig. It was a drill rig. It was a vessel. It was hired by the charterer of that vessel, the drill rig, to bring supplies to the drilling rig, operated by the drilling company. But the charterer didn't pay for these supplies that Trico's supply boats delivered to the drilling rig. And the court recognized the party that carried and delivered those essentials to the drilling rig, to the drilling vessel, had a lien against that vessel by virtue of its delivery of those essential items. I would submit that the oil fuel drill pipe were likely necessaries on their own, but the service of bringing them, the court declared, was sufficient to create maritime lien benefit in favor of the transporting party. And I submit to you here, we are the transporting party, delivered it to the receiving vessel.
One additional question I would pick you up on your argument with regard to the strictness with which we interpret the land statute itself. The Valero and Atlantic Gulf stevedores, as well as the opinion we've been talking about, most recent opinion, in Martin Energy, all start with that basic premise itself that these are to be strictly construed. That's the exact quote of it. It says, "We apply the provisions of similar stricti juris to ensure that maritime lands are not lightly extended by construction, analogy, or inference." So that I just want to pick you up on that. To me, that still is the metric, and if there's something else I should know.
Your Honor, if I can respectfully address that. The stricti juris discussion is we're not going to create new classes of liens. That's strict. But the Act speaks in terms of other necessaries. And when you look at other necessaries, that's not what stricti juris is looking at. You can't create new categories, but the category of the categories of necessaries exist. And if I can quote the Fifth Circuit, which says, "We are of the further opinion that the Lien Act is not to be viewed through the constricting glass of stricti juris, or, as some would suggest, strictissimi juris." I said it wrong earlier. "We view the legislative history of these sections, 1979, but that point has not been reversed. And that's why I explained, Your Honor, the case that talks about stricti juris does not talk about expanding or not expanding other necessaries. It didn't focus on that aspect.
Strictly on line with applying the strict rule.
Well, I would submit that the earlier case represents a congressional intent that it should be given a broad application. The Martin Energy case said, look at the category broadly, which is the opposite, I think, of the point that you're suggesting that the stricti juris comment. Martin Energy did not withdraw the broad view of necessaries. And, Your Honor, I submit that what we did meets the narrow view, but a broader view would certainly permit that in this case.
We've got your argument. You've got time.
Yes, it is. Your Honor, I'll come back for the rebuttal. I appreciate the questions, Your Honor. Thank you.
Good morning, Your Honors. Miles Clements of the Phelps Dunbar Law Firm, appearing on behalf of Goliath Offshore and the motor vessel Nor Goliath. My opponent comes before you today in an attempt to expand the relevant statute similar, and he does so to allow a lien against my vessel for services not furnished directly to it. He does it without any supporting jurisprudence or statutory precedent. He does so without his clients even having a contract with my derrick ship, my heavy lift ship. He does so without having tugs which serviced my vessel and disregarding controlling Fifth Circuit precedent, namely the Martin Energy case and other jurisprudence, but I would submit that Martin Energy is the glove that fits this hand, and that my opponent misconstrues its holding and reads it as an advocate, but I think a reasonable reading would lead one to a different conclusion and appreciate the court's different interpretation of similar, a stricti juris statute which is not to be expanded by inference, by analogy, or lightly. Here we have, not as my opponent suggests, a heavy lift ship which is deconstructing a platform. That is Epic's mission. That is what Epic was hired to do. We're hired to lift components, steel components of a structure which other companies are deconstructing, all at the direction of Epic. Now, the Goliath houses many of those employees, but it does not direct them, and it's not out there to perform the overall task, the overall project of a platform decommission or deconstruction. It's there to heavy lift and do so at Epic's direction. And all of these vessels in this fleet chartered by Epic, you've got inland tugs, you've got offshore tugs, you've got numerous contractors. They are all working for Epic to perform Epic's project as Epic sees fit. Now, these tugs, they do furnish a service, but they do so to the barges which they have been hired to move around. The barges are the objects, are the things to which a direct service is provided on this project by these tugs. Ergo, that gives rise by these tugs against lien rights against those barges. And the tugs have, in this litigation in the court below, have asserted those liens against those barges. That is their remedy. Here, for whatever reasons, commercial or otherwise, they are seeking to expand SIMLA to get a lien not against the barges who are the direct beneficiaries of their services, but my client's heavy lift vessel. And
could I ask?
Yes, please.
Would it make sense for us to think about this as a distinction between the vessel's functioning and the objects of the vessel's functioning in a way that a necessary enables the vessel's ability to do its basic movements like lifting, but the objects that the vessel acts upon, the items that are lifted, are not necessaries? You know, if it was, I'm trying to figure out if that's the way to look at it, that it's not, your client is lifting,
Correct.
but it's not what it lifts, it's the lifting function. And so
Right.
if this were related directly to the lifting function, then it could, there hypothetically could be something that could have a lien, but this is the thing being lifted, which is not necessary for the lifting function. I'm trying to think if that's a way to think about it.
That is correct. It is what Epic, the owner of the project, wants to be lifted. The Goliath is out there to lift whatever Epic wants it to lift. And it can, and those steel components it can lift, it can hold, doesn't have to put them anywhere. It can transport them under its own motor power. It is self-propelled. Our derrick barge is self-propelled. And it doesn't have buoys. It's got a dynamic positioning system. It doesn't require tugs to move buoys around to hold it in place. All of these vessels serve Epic's purposes, and under the controlling jurisprudence, they simply don't have liens against each other. The Bibby offshore case, granted, it's a district court decision, but I believe it's persuasive authority, and it's the other glove which fits this hand. And it explains that when, in that case, there was a lay barge laying pipe and there was a diving vessel, they both needed each other to get the pipe assembled and in place, without which this project couldn't go forward. They served the interests of the owner of the project, and though there was a synergistic relationship between these tasks to perform the overall job, they were not deemed to be providing necessaries to each other, and consequently liens against each other did not exist. Similarly here we have that situation. The barges could not move without these tugs. And if you consider, you know, if appellant's argument becomes the law and new law, then you've got an ever-going, non-ending daisy chain of companies providing alleged necessaries to each other. Why wouldn't the tankerman at the fuel dock who pumps fuel into a tug, which then pushes a barge out to some offshore location, why not, if he didn't get his wages, why wouldn't he have a lien against the vessel, the derrick vessel, or the ultimate vessel at the end of that chain? You would have, I would say, a circular firing squad of every contractor and subcontractor with any connection to this project shooting at each other. And the winner would be the shooter with the biggest gun. That would be my client, because we lost millions on this project. We didn't get paid, and we're defending all these liens by people who Epic stiffed as well. So, you know, ultimately we lose this case. It's a Pyrrhic victory for our opponent, but I'm digressing. You get the point. If every entity, every vessel involved in a project could lien another vessel involved in the project, you'd have an ongoing daisy chain. And look, we can all appreciate, you can read the jurisprudence, and you know the jurisprudence. Liens under the General Maritime Law originated when ships pulled into ports. There was foreign ownership. To continue their voyage, they might need provisions, crew, fuel, repairs. Those are the things that were specifically enumerated in the earlier iterations of the SIMLA statute, and without which the ship could not sail. And its owners were foreign, credit was not reliable, and the Lien Act historically developed so that the ship could not sail on its debts. Well, now, in the modern context, the basic tenets, the rationale for the lien law under the maritime law, my opponent would have extended irrationally and unreasonably, and beyond which SIMLA was intended to apply. Again, my opponent has overstated the role of Goliath. All of these contractors were working at the direction of Epic, and they performed their discrete tasks in a synergistic fashion. Those tasks may have enabled other tasks performed, but here, Goliath did not need a tug to perform its heavy lifts. The Martin Energy case is certainly applicable under its facts, in which fuel, you would think fuel certainly is a necessary. It's in the statute. It is a necessary, but in Martin Energy, the supply vessel delivered that fuel not to the user. It delivered it directly to another vessel who delivered it to the user. It is required under General Maritime Lien Law and SIMLA for a lien to lie against the vessel which uses the product. And that's why I believe, and I respectfully submit, Martin Energy is dispositive. The Trico Marine case is mentioned by my opponent. Again, in Trico Marine, we're dealing with things, products without which the Trico vessel, a drilling vessel, could not operate. Fuel, lube oil, drill pipe, and casing. I would say if we were dealing with heavy lift rigging, that is something that the Goliath requires to perform its heavy lifts, fuel, lube oil. But that's not what we're dealing with here. The tugs didn't furnish those things to Nor Goliath, fuel, lube oil, rigging, any of that. It was a much more remote activity by the tugs vis-a-vis the Nor Goliath. So these cases hold that it is only those vessels to which these necessaries, these things essential to their operation, are directly provided against which a lien can arise. This is a motion for summary judgment granted in the court below. But all of these principles are a matter of law, and that law is well established, and that law was confirmed in Martin Energy Services 2 years ago. There is no reason for this court to expand or overturn that jurisprudential law or expand the statute, the similar statute. It's stricti juris. Appellant has his remedy versus the barges. There's no reason for you to create new law in this case, simply to have these liens reach as far as the Nor Goliath, and again, create the circular firing squad. I would suggest, if my opponent's going to use a rebuttal, time for a rebuttal, that he explains to us how the tugs can't execute their lien rights against the barges, to whom they provided direct services. Barges have no motor power of their own. They can't get in the game. They can't be a player in this project unless a tug moves it out to offshore. Here you'd have an inland tug moving a barge to the Eugene Island Sea Buoy and an offshore tug taking it off, but they're both moving the barge. The court below expressly held, record excerpts, page 85, that a maritime lien attaches only to the specific vessel to which services are provided. I would like my opponent to explain what precedent is contrary to that holding. There is no precedent. The precedents favor my client. And given that authority, we would respectfully ask your honors to uphold the law that's established in this circuit and not create an endless road that would do nothing more than confuse the industry and be an impediment to maritime commerce. If there are no other questions, your honors, I'll sit down.
Thank you, counsel.
Thank you.
We'll address the questions that were presented. Whether my clients have a lien against the barges themselves does not ignore the fact that my clients provided necessary services to the Nor Goliath. My opponent would suggest that his client is only a lift vessel, but it's not just a lift vessel. It lifts and it lands, and it goes back and lifts and it lands. And it can only do that if it has the necessary tools, and that is these barges and the motive power that bring the barges to and from. The fact that there may be a lien right against the barges that it handled does not destroy the right of my clients to bring a lien claim against the party that actually received the benefit of those services directly. This is not an expansion of the law. It's simply taking what are other necessaries, taking the holdings of this circuit as to a broad application, and we've given references to both the Trico case, which gave the carrying party that carried the pipe to the receiving vessel a lien right. Martin Energy said the fuel that was carried The carrying vessel didn't have it there, but the receiving vessel did. So it's the receiving of the benefit is the key to determining what's necessary. The Goliath had to have the benefits of my towers in order to perform its services. We did provide the services directly to the Goliath. So this is not some circular firing squad. We are focused and aiming directly at the Goliath here because it is the one that got the benefit that was ordered by its charterer. My opponent suggests, gee, there's no contract between my tower and his client. But none of the cases require a contract. Indeed, in the Trico Marine case, the contract was between the charter who chartered the drilling rig, and the contract was with the supplier of the services in that case, and that created a lien, even though it didn't have a contract. The lien holder didn't have a contract with the drilling rig owner. The drilling rig owner was innocent. They didn't owe the money, but under the maritime law, the provider of the service had the benefit of that security. And that's what my towing companies want, is the benefit of the security that the general maritime law provides. We submit that the Trico case, the Martin case, indeed support our case. They are not contrary to our position. The law is broad. We've cited the cases where cigarettes given to a shrimp boat is considered a necessary, liquor to a pleasure yacht, linens to a floating hotel, an insurance policy that's not even delivered. It doesn't have to be in a direct receipt if you receive the benefit of something that is necessary, and that's happened here. Your Honor, the material facts are really not in dispute. It was a summary judgment, and we submit the district court erred in applying the law to the facts of the case. In summary, the Goliath absolutely needed these services to perform its job. The Goliath position ignores the broad.
I'm suggesting this is a fact question.
No, it's not a fact question.
Just want to make sure.
The towing companies relied on the credit of the Goliath. They had no intention of waiving that. That's in the record. We request that this court remand this case back to the district court with instructions to reverse the order against my clients and render a judgment in favor of the towing companies because the amounts of their claims are in the lower court record. The district court was in a position to have granted this motion. We submit that the court was erroneous in its application of the law as we have presented it to the court today, that the court did not render its rulings consistent with the longstanding and consistent rulings of this court regarding what are other necessaries, not creating a new lien, Your Honor, not creating a circular fire squad or endless succession. This was directly hands-on benefit provided to the Goliath, which could not function without my client's services. We sincerely appreciate the court's attention today and the questions that we received. I will welcome any more questions the court may have.
And I appreciate the Maritime Bar. I find that over the years that they come here prepared and argue their cases well. I think it's because you have such great access to us over the code. Walk across the street, but I do appreciate that.
Thank you very much, Shep. We appreciate it.
That will conclude the arguments for today. The court is in recess until 9 o'clock in the morning. Thank you.